So hi everybody, welcome back to Law Hero. My name is Jen and I make videos about the law roughly every week. If it's a bad week I won't make a video. And yeah, this evening we're going to look generally at commercial law, because commercial law, the term isn't defined anywhere. Saki, shh. Commercial law isn't defined anywhere, so it's more of a broad concept. Like it brings in, for example, business law, agency, contract, like the Companies Acts, sale of goods, supply services, payment, taking security, insurance, IP, competition law, and consumer protection, and also dispute resolution, because disputes happen between businesses. So it's commercial law is a very broad type of law. So when you come across a firm who practices commercial law, you need to understand that they do all of those things, and then they do all of those things and on a specialist basis. So for example, they might do pharmaceuticals, they might do environmental law, because those two areas are regulated and commercial entities operate in those areas, and that's why the commercial law firms do them. It's like a value added service, which means they have deep knowledge in a certain sector or industry that adds value to their clients. Okay, but we're not going to talk about that this evening. This evening we're going to talk about commercial law generally, and I'm relying quite heavily on Mr. Michael Ford's book, because that for me has been the holy grail when it comes to commercial law conceptualization in Ireland. And to be quite frank with you, I did not qualify in this area. So as most of you know, I qualified into capital markets, which is finance. So I was always a finance lawyer. I even did an LLM in finance, and that's what I always wanted to do. But like anything in life, you can never tell how your life is going to go. And actually what's after happening is I've become a commercial contracts lawyer, and I focus on data, IP, IT, and competition law, litigation. I've become a real generalist. But to be a generalist in-house, you need to have a very good grasp of commercial law. Okay, so we're just going to dive into Ford's definition of commercial law, which is: commercial law concerns principally commercial transactions, meaning dealings between business people or organizations, or between them and individuals who are acquiring or disposing of some product or service, including state regulation of these transactions. There's a whole lot in that. And the list that I mentioned at the very start of the video, that is basically that list, okay? Okay, so when you think of commercial law, the very first thing you have to ask yourself is, who are the commercial actors? And in Ireland, we have sole traders, right? So these are usually self-employed business people. They're usually not like a professional. And when I say professional, I don't mean that they're not professional. What I mean is they're not considered a professional body, like accountants or solicitors, or doctors or dentists, as in like it's not a regulated profession. That's what I mean by not professional. Don't take it up the wrong way. And all you basically need to do as a sole trader is register your business name under the 1963 Registration of Business Names Act, and you have to pay income tax. That's it basically. Obviously, if you're not incorporated, you don't get all the benefits of limited liability. See your FE1 notes for more, but you people know what I mean by that. We also have partnerships. A nice definition is the relationship which subsists between persons carrying out a business in common with a view to profit, other than a registered or incorporated company. So partnership is basically like a sole trader, but there's more than one person. Obviously with a sole trader, you can only have one individual. And then the size of partnerships is actually regulated by your Companies Act, section 1435 and 1436. It's actually 20 partners and 10 for banking. The distinctive feature of partnership is that it is unlimited liability. You can avoid this by signing up to the Limited Partnership Act 1907, but very rarely does that happen. And corporate bodies such as registered companies can become partners or limited partners. Right, registered companies, we don't need to go through that because we know that very, very well. This is any company registered under the Companies Act 2014. But did you know that there is no upper age limit on directors? And also to register a company, there is no stipulation to register a company. There's only stipulations around directors. The registered owners of its shares need not be the beneficial owner of the company. Obviously, a registered company has separate legal identity and limited liability. I won't talk about unregistered companies because they're very few and far between. Foreign companies are registered abroad and they actually do business in Ireland through their agents or subsidiaries. And the example he gives is Arthur Guinness Son & Co. Dublin Limited, which is a wholly owned subsidiary of Diageo PLC, which is registered in England. There are special businesses called societies which come under the Industrial and Provident Societies Acts 1893 to 2014, and these are your credit unions and your building societies. Trusts are obviously not-for-profit structures, legal structures. So for example, private hospitals, the GAA, the Irish Rugby Football Union, political parties, charities are usually set up under a company limited by a guarantee, a CLG. So they're not trusts, but the CLG kind of follows the trust structure in that the directors are like the trustees, but there is liability in that the liability is the guarantee, but the guarantee is usually nominal. Then there's some statutory corporations in Ireland. One, for example, is the Dublin General Cemetery Companies Act of 1933, but the most well known are probably NAMA and the ESB. Okay, so we all know the sources of law in Ireland. We have our precedent, which is judge-made law. We have contracts, and we have freedom of contract between different parties. And usually what you write in the contract is what is taken by the judge to be what you meant. Usually, and that comes down to interpretation of contracts. Usually you'll have some boilerplate clauses, like for example, no partnership or agency, your jurisdiction, severability, that kind of stuff at the back. There's some implied terms, usually in consumer contracts. There's no requirement of good faith under Irish law, whereas for example under German contract law there is. Exclusion clauses then are basically a mechanism to exonerate one party's liability to the other under the contract. And usually if you're seeking to defend yourself from an exclusion clause, you would use the contra preferentum rule. It's usually used by people, for example, in mortgage cases, or if they've signed a guarantee or some kind of a promise without their knowledge. We have unconscionability, which is usually used in contract law, especially if it's, for example, no longer viable to perform the contract. And also penalties cannot be disproportionate. So this is a general rule against penalties unless it was a genuine pre-estimate of the loss. We also have condition warranties and inanimate terms. I've gone through those many times on this channel. Just remember, inanimate terms comes from the Hong Kong Furs case, and basically inanimate, always think of, when you think of inanimate terms, I always think of intermediate, because it doesn't fall within a condition or a warranty, it just goes in the middle. So look up the Hong Kong Furs case if you want to understand more about that. Pre-agreement representations are usually expressly excluded when you come to the actual contract. So you'll put in some wording that will say like any representations made before this agreement are hereby excluded, and this is the entire agreement. That's why you have an entire agreement clause. So for radically changed circumstances, and like, so for example, you would use unconscionability when your economic status has changed, you know, or it becomes no longer viable or profitable to continue on the contract, or for example, you were sold a certain amount of units and in no way would you ever sell those units, that kind of thing. Whereas force majeure and frustration are much different. They're when circumstances outside your control make it completely impossible for you to perform the contract. It's like frustration or impossibility. Force majeure then is an act of God, like, you know, some terrorist attack, or the weather, or the pandemic has been used as a good one. And then just to know, in the UK they actually have a Law Reform Frustrated Contracts Act. We don't have it. And in the UK as well, they have the 99 Contracts Right of Third Parties Act, and we don't actually have that either. We have privity of contract in case law, but they actually have it in statute. Tort and equity then are also important when it comes to commercial actors in Ireland operating. You have to understand the concepts of negligence, especially for tort, and in equity equity is also important as well. And like, these are all the things that new or foreign actors should know when they're coming into this jurisdiction, that equity can be used for certain defences that are like outside of contract. The impact that you know, private international law has had on the sale of goods, and as well as that EU law, especially when it comes to sale of goods and supply services. Also competition law, like EU law is very prevalent when it comes to competition law. And then the last area where you need to consider when you're acting in the state of Ireland is the Constitution, the Charter of Fundamental Rights, and the European Convention on Protection of Human Rights and Fundamental Freedoms. They're also to be considered. How do you implement commercial law in Ireland? Well, the simplest way is self-help and to use your dispute resolution clauses under your contract. You may go to a state agency. For example, if you're a consumer, you can go to the CCPC, you can go to the Financial Ombudsman. For example, you can go to the Aviation Commission if it's to do with aviation. You can take a civil action, you can go to court, obviously. You can take a criminal action. You can also, for example, if it's a competition law, you can apply to the state aid regimes which are enforced by the European Commission. So that is a whistle-stop tour of, like, very broadly commercial law in Ireland. The next topic I'll be moving on to is agency, which is very important. These videos are to be like very broad, and just to give you like a broad sense before you go into a law firm for the very first time, and just educate yourself a little bit around the actors and get like a helicopter view before you start operating, because a lot of the time people don't really see how the tectonic plates fit together. Thank you very much for listening, and I'll see you in the next one.